Wherever you want.
Okay. Well, I just want to thank y'all for coming. So I'm about to introduce Josh Blackman. Y'all know him, but Josh Blackman is a national thought leader and leader on constitutional law in the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials. He's testified before Congress and advised federal and state lawmakers. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He's published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. Since 2012, he has served as a professor at South Texas College of Law, Houston. Josh is also an adjunct scholar at the Cato Institute. Josh has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Josh has written more than 5 dozen law review articles that have been cited nearly 1,000 times. Josh was selected by Forbes magazine as 30 under 30 in law and policy. Josh is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. So,
Thank you.
Up to you.
Thank you so much. It's a pleasure to be back here at South Texas. My first actual event in a year and a half. I'm not teaching this term. All right, we have an ambitious project ahead of us. My goal, if I succeed, we to walk through the entire Constitution in 1 hour. Ready? Hang on. We'll start at the beginning, and we'll finish at the end. The Constitution begins with the Preamble, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. To ordain and establish this Constitution for the United States of America. This is the part most people quote, but they don't actually ever read. It's an important message to begin because it explains it's not a finished product. It's a process, and the process itself is spelled out in the Constitution of how we ensure for ourselves and our future we obtain these blessings of liberty. The structure of the Constitution makes a lot of sense. It's divided into articles. The first article governs Congress, Article 1. And Article 1 explains that Congress exists and has a legislative powers. The separation of powers is built into the Constitution. You have the executive, judicial, and the legislative. The legislative spelled out in Article 1 of the Constitution. And there are 2 bodies. This was a compromise. There's the House and the Senate. The Senate is fixed. Each state has 2 senators. And the Congress is based on population. This was a compromise to have big states and little states given equal treatment. But the very first 5 words are important. All legislative powers herein granted. Congress does not have unlimited powers. They have the powers granted in the Constitution. And if the power is not granted in the Constitution, then Congress doesn't have it. Rather, that power belongs to the states. We learn that the House has members who are chosen every 2 years. Minimum age of 25, you have to be a citizen. Then we come to this provision. People don't like reading, but it's an important history of the Constitution. When we speak of representation, we're counting people. But people weren't always counted in the same fashion, nor were they taxed in the same fashion. This is a provision known as the 3/5 clause, but people don't really understand how this worked. At the time, southern states wanted to count their slaves as 100%. Why? The more people you have, the more representation you have. It was actually the northern states that didn't want to count the slaves because that would give the South much more power in the legislature. So the compromise was struck that for purposes of representation and taxation, only 3/5 were counted of other persons, not slaves. They don't use the word slaves, but of other persons. This was a so-called 3/5 compromise. Okay? And we have the Senate. The Senate is fixed. Every state has 2 senators regardless of population. So very big Virginia, very big Pennsylvania, and itty-bitty New Hampshire had the same representation in Congress. Senators had to be 30 years of age. I think most of you are probably not eligible yet. I am. And 9 years as citizen. And then there's this vice president. Who's the vice president? We'll learn more about him later. We know all too well the Senate tries impeachments. We have too many of those in the last couple of years. I think since COVID, we had 2 presidential impeachments, if my memory serves. while we were gone. We learned the Chief Justice presides at them. Congress can set regulations about elections, but generally the states have the first crack at it, which is going to be a very important piece of law very soon. The House decides who its members are and how they're accepted, and that's going to also expel with a 2/3 vote any member who misbehaves. Does not happen very often. The salary for the senators is paid for by the federal government, not by the states, because he who pays the piper calls the tune, a very important aspect of constitutional law. Okay. Taxing. Taxes must originate in the House closest to the people. This becomes a very important point when taxes are increased. How does the bill become a law? Passes the House, passes the Senate, and is presented to the president. The president can sign it, which makes it a law, or he can veto it. If he vetoes it, he can override the veto with a 2/3 vote. This was an important change because the king could not be vetoed. This was a shift from how our friends on the other side of the Atlantic structured their system of government. If you've taken me, see my face for 1 second, I'm teasing you, right? If you've taken me for con law, and if you have anyone else for common law, we probably spend the first half of the semester on this one part of the Constitution. Article 1, Section 8. Article 1, Section 8 lists all of the powers that Congress has. Anything that Congress does, with a few exceptions, must be found in Article 1, Section 8. They have the power to lay and collect taxes and to borrow money. The third one's a biggie. You'll spend probably a month on this in law school. The power to regulate commerce among the several states. This provision has been used to justify sweeping regulations of all activity that don't really even cross state lines. Congress can establish rules for naturalization, that is immigration, rules for bankruptcy, rules for printing and coining money, punishing counterfeits, establishing post office. May not seem very important, but before the internet, post offices were really important to get things around. If you've taken intellectual property, they can promote science and useful arts. This is where patents come from. They can create inferior courts, that is the lower federal courts. They can punish piracy. Piracy was a very big deal back then. It doesn't matter much today. Occasionally there's Somalian pirates, but this was a huge deal in the 18th century. Congress can declare war, not the president, not the king. The Congress declares war, although the executive doesn't follow that one too much anymore. Congress can raise and support armies. They can provide a navy. They can call forth the militia. They can exercise control over the DC, the federal district, national capital. And then we get to this last one, number 17. This is probably top 5 most important parts of the Constitution. Congress's powers are not so limited to that which is enumerated. They can also enact laws that are necessary and proper to carry into execution the other powers, clauses 1 through 16. The necessary and proper clauses used to carry into execution clauses 1 through 16. The scope of Congress's implied powers in the necessary and proper clause presented one of the first major debates. Can Congress charter a bank? Hamilton said yes. Jefferson and Madison said no. Chief Justice Marshall, a bit overrated in my book, agreed with Hamilton. And that's McCulloch v. Maryland, way overrated. Article 1, Section 9 imposes restrictions on the states. The first one is called the Slave Trade Clause. The Constitution says the slave trade, which was an odious practice, could not be banned until the year 1808. Another compromise. Leave this practice in place, get the Constitution ratified. Hopefully in 20 years we'll be in a different place. And indeed it was ratified, it was repealed in 1808. Habeas corpus governs rights of prisoners. No ex post facto laws. You can't criminalize something after the fact. The executive can't take money from the Treasury without a congressional authorization. All money must be authorized by Congress. Then we have some more restrictions on the states. States can't enter into treaties or alliances. They can't grant titles of nobility. No Prince Josh, right? We're not going to have that. Although Texas does issue, like, remember the admiral of the Texas Navy. You can't get that. It's kind of cool, but it's not nobility. We go down. So far, all Article 1, that's the powers of Congress. Now we have Article 2. which is the power of the executive. You'll find it's far shorter. Congress did not spell out the powers of the executive with as much precision as the powers of Congress. We find that there's a president of the United States, not a king, a president. And the executive power, whatever that is, doesn't say, shall be vested in the president. What is the executive power? That's probably the second quarter of your semester in common law. We don't know. It's not a term that's defined, and it's quite open to different interpretations. There's a lot of discussion of how the president's elected. It's pretty complex. If you ever hate the Electoral College, that's your section. Then we get here. The United States president must be a natural-born citizen or a citizen of the United States when the Constitution was adopted. If the president cannot do his job, the VP steps up, which is a huge backup plan. Okay? The president's the commander-in-chief. Exactly what that means, we don't know. The president can issue pardons. The president can make treaties, but the treaties must be approved by the Senate. He can make nominations of ambassadors and judges and other positions, but he needs consent of the Congress. See the checks and balances. The president cannot act by himself. He only acts with the aid of those around him in the legislative branch. Okay? The president shall take care of the laws and faithfully execute. This is a very important obligation. The president cannot suspend the laws. He can't say, you know what, I'm going to ignore the law. I don't like it. He must faithfully execute the laws passed by the Congress. Yep, we know president can be removed from office in impeachment. We've had 2 trials in the last year and a half. We had, one in 150 years and another one. Okay, so we got a bunch of these recent years. And that's it for the executive. I'm done. Compare the length of Article 1 for Congress, the length of Article 2 for the executive. There's so much less said about the executive power. They left much of that open. Then we get to Article 3, which discusses the judiciary, what Hamilton called the least dangerous branch. Weird if he was right or not. It begins, the judicial power of the United States shall be vested in one Supreme Court. So this Supreme Court is referenced in the Constitution itself and in other courts, inferior courts, that Congress can establish. If Congress wanted to, they maybe never establish any lower court, just make one Supreme Court, have all the appeals with the state court. They could have done that. They didn't. They made lots of courts. Okay? And the judges have tenure. They serve during good behavior. Okay, what does that mean? They don't work at someone else's pleasure. They cannot be fired for doing a decision people dislike. In England, the judges served at the king's pleasure. The king could fire any judge whenever he wanted. So our judges have independence. They can rule against the government and not fear losing their jobs. We've had very few judges impeached, removed from office. They've generally done that for crimes. So judicial independence is a core element of our Constitution, which leads to basically life tenure. And so we have judges in their late 80s, like, I'm going to live forever, right? YOLO. Yeah. No other country in the world has life tenure judges with that retirement age. So we are somewhat unique in that regard. Then we get Section 2. The judicial power shall extend to all cases of law and equity arising under the Constitution. Remember Section 1331 in Civ Pro arising under? Yeah, that's where it came from, right? Civ Pro is common law, right? Everything in Civ Pro is based on us, right? We started first, and you guys just make code later. Controversies, right, between citizens of different states. Diversity of jurisdiction, 1332. Yeah, that's where it came from, right? The jurisdiction of the federal courts is premised on this part of the Constitution. Congress can only create diversity of jurisdiction because of this section. We also know about the Supreme Court's original jurisdiction. If you've read Marbury vs. Madison, you know all too well that apparently Congress cannot expand original jurisdiction. I don't know if that's right, but again, John Marshall, overrated. It's true, he was. Okay. And that's it. There's very little said about the court. So a lot is said about Congress. A lot is said about very little said about the executive, and almost even less is said about the judicial. What is a legislative power? The Congress spells it out with precision. 1, 2, 3, 17. What is the executive power? We don't really know. What is the judicial power? We don't really know. This gap has led to major debates for the last 230 odd years about what these provisions ought to mean. All right, rolling along, making very good progress. We go down to Article 1, Section 4. I'm sorry, Article 4, Section 1. Sorry, I inverted it in my head. Okay? Article 4, Section 1 governs the relationship between states. The relationship between states. Okay? States must give full faith and credit to contracts. So if you form a contract in Texas, Oklahoma courts to enforce it. Very important principle of federal law. Citizens are entitled to things called privileges and immunities. These are rights. So if I'm a Texas citizen and I move to Oklahoma, Oklahoma cannot deny me the rights it gives its own citizens. This is a non-discrimination provision. Query if slaves were citizens, because if they were, they're entitled to rights. This was a huge debate in early slavery constructions, right? What about a freedman, a person who's freed from slavery? If you were a sailor in Boston and you traveled down to South Carolina, could South Carolina deny you the rights? A lot of debate about this issue. Okay? This is the third major compromise over slavery. The first was the 3/5 clause. The second was the slave trade clause. This is called the Fugitive Slave Clause. This is probably the most dangerous provision of the Constitution from the point of view of slavery. If a person held to service, which was a way of saying a slave, they didn't use the word slave again, escapes to another state, the person must be returned. This provision allowed for the enactment of the Fugitive Slave Act, which you may have studied or maybe didn't. This is what allowed Southerners to prevent runaway slaves to go north and bring them back. This was a very dangerous provision of law. The 3/5 clause was a compromise. The slave trade clause was a compromise. This was an outright victory for the South. Outright victory. This was devastating. And if you take them for common law, you'll see why. But this was a huge blow to the cause of abolitionism in the United States. Okay? Section 3, about the admission of new states. Section 4, a Republican form of government. Doesn't mean Republican Party, it means representative. But they're guaranteed that. Article 5, how do you actually change the Constitution? It is not easy. It's only happened about 24 times in 200 years. 2/3 of both houses of Congress proposed an amendment, and then 3/4 of the states ratified. That is very hard. Today, that would mean 30-something states have to propose the amendment. It's not going to happen. I don't think, at least. Okay, almost done. Article 6. This is the Supremacy Clause. I said the Necessary and Proper Clause is probably one of the most important provisions. This is the most important provision. Without the Supremacy Clause, we don't have a constitution. The laws of the United States and the Constitution are supreme, and they trump any state law to the contrary. Unless you have supremacy of federal law, you don't have a union. You need this provision to make it together. This is the glue that keeps the Constitution intact. Article 7, Constitution becomes ratified when 9 states approve. Oh, Josh, weren't there 13 states? Yeah. It became effective before all the states agreed. In fact, 2 states didn't even agree with it. They sort of had to tag along later. I think it was North Carolina and Rhode Island, if memory serves. Okay? We're done with the Constitution. The Constitution was ratified in 1788, but it was signed on September 17th, 1787. That's why we're here a little bit early. But that's why we're here this week, right? It's a Constitution Day, September 17th. That's a Friday, and no one's actually here on Friday, so we're doing it here. And happy to see all your smiling faces. But we're not done, right? The Constitution did not stop in its tracks in 1788. We've had a number of amendments. So the bulk of my talk will be discussing the constitutional amendments. We start with the First Amendment, which was not actually the first proposed amendment. It was actually the third proposed amendment. The first 2 are unimportant, were never ratified. Or actually, one was ratified 200 years later. So they say the First Amendment's first, most important, it was actually the third. So that little narrative doesn't actually work. All right, so the First Amendment has several basic freedoms. Congress cannot establish religion. Congress cannot prohibit the free exercise of religion. They can't violate the freedom of speech. They can't violate the freedom of the press. They can't violate the freedom of assembly. And they can't violate the freedom of petition for redress of grievances, basically complain to the government. Now, the first word there is important. Congress, not the states, Congress. As originally ratified, the Constitution only governed the federal government. It did not limit state power. So states could have established churches. The states could have laws banning the press. This would not change until the 1860s, or perhaps even later with the 14th Amendment. Okay? In fact, in the early 1800s, many states had established churches. Many states restricted press freedoms quite heavily. So this was something that only governed federal power. The Second Amendment, one of our favorites here, is controversial to this day. Does this govern the rights of individuals, or does it govern the right of Congress to regulate state militias? The Supreme Court has said it's an individual right, although this is an open issue. People don't like to agree on. The Third Amendment is probably the most obscure part of the Constitution, but it's a good one. The government can't quarter troops in your home. This doesn't happen very often, but it does happen. There was one case I remember where there was a sting operation, and the police wanted to sit in some guy's apartment watching some crime scene, and he brought a Third Amendment claim. There was another case involving some natural disaster, and a park ranger basically said, "I need to stay in your house because I'm going to get injured by some storm or something." Kind of the safe harbor doctrine and torts, if you will. But it's still there, has not been repealed yet. If you've taken criminal procedure, or if you work in the DA's office, I think as some of you are, you know about the Fourth Amendment. It's very important that the government cannot perform unreasonable searches and seizures, and you need probable cause to establish a warrant. The Fifth Amendment is a bit of a hodgepodge. It's a little bit of everything. It has a double jeopardy clause. I plead the Fifth. It's the Fifth Amendment. You can't be compelled to testify against yourself. It's a very basic principle. And then the due process clause. You cannot be deprived of life, liberty, or property without the due process of law. What is the due process of law? Does that only govern procedures, or does that mean something more, that it has to be fair? Does it involve some kinds of unenumerated rights? We'll come back to that later. And if you've taken me for property, which I think a couple of you have the takings clause, that you cannot take property without just compensation, which means they can take property if they pay you for it, if it's for a public use. What a public use is, the courts still fight over. Okay, that is the Fifth Amendment. The Sixth Amendment also is a bit of a grab bag. Several criminal procedure rights. People have the right to a speedy trial by an impartial jury. You have the right to confront witnesses. So if someone testifies against you, you have the right to cross-examine them, which is a very basic tenet of due process. You have the right to assistance of counsel as well. That doesn't mean paid assistance of counsel, although the Supreme Court would say otherwise in Gideon v. Wainwright. Seventh Amendment does not get much love, but it's right to civil jury trial. $20? It's actually still $20. That amount's never been changed. There's no inflation. So you have the right to a civil jury trial, but practically speaking, not really. Right? People settle everything out of court. The Eighth Amendment, you may study in criminal procedure, governs punishment. You can't have excessive fines, and you can't have cruel and unusual punishment. Now, does that mean the death penalty is cruel and unusual? At the time of the Constitution, people were regularly executed. In fact, the only punishment for most crimes was execution. In fact, it says you can be deprived of your life with due process, but some people think that the death penalty itself is unconstitutional for a host of reasons. We get to the Ninth Amendment, which is sort of an obscure one. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So there's an easy way to read it and a hard way to read it. The easy way is there's some rights we have that are not written down. Right? And just because some rights not written down doesn't mean it's invisible. The harder way is, what are those rights? Right? How do we know what rights are if they're not written down? Are there unenumerated rights, rights that are invisible to the Constitution that courts still ought to protect? My colleague Randy Barnett is probably the national expert in the Ninth Amendment. Go read his book if you want to know more. Amendment number 10, the 10th Amendment. It says the powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states or to the people. What does that mean? If Congress is not given a power expressly, that power is retained by the people. It's a very basic principle. In practice, it gets a little messy. All right. The first 10 amendments, which are now known as the Bill of Rights, were ratified in 1791. So you have, let's get your dates straight. Constitution signed 1787. Constitution ratified 1788. Bill of Rights proposed in 1789, ratified in 91. So in the span of 4 years, you go from nothing to a Constitution with 10 amendments. After that, things slowed down a bit, right? The amendments become much more sporadic. The 11th Amendment governs what's called sovereign immunity. It basically means you cannot sue a state. Well, if you read it, the text is a little bit messy. Take me for Conlon, we'll talk about the 11th Amendment. The 12th Amendment governs election, right? Originally, you had the president and the vice president running against each other, right? They didn't run in the same ticket. Whoever got the first votes would be president. Whoever got the second most votes was vice president. If you ever see the Hamilton musical, there's one scene where Jefferson becomes president and Aaron Burr becomes vice president. And it's like, I'm your vice president. And Jefferson's like, well, we can change that, right? 12th Amendment, right? You see, yeah. But then Jefferson says, I can do it, I'm president, which is a bit of an exaggeration, but it was changed by the 12th Amendment. Then there are no new amendments until 1865. So you basically go from the 1800s to 1865 with the 13th Amendment. The 13th Amendment was enacted after slavery. If you watch the movie Lincoln, the entire movie is about the 13th Amendment, which I didn't like the movie. I thought it was a little bit boring, but you think I'd like the movie about the Constitution? I didn't like it, but it's okay. 13th Amendment, neither slavery nor involuntary servitude shall exist in the United States. Boom. Ban slavery nationwide. And not just slavery, slavery and involuntary servitude. I think today we think that slavery and involuntary servitude are the same thing. They're not the same. They're different terms listed separately. I think slavery is actually broader than involuntary chattel servitude. It involved a system of oppression. I think it's an important point. And also, Congress can enforce this. So if states still have slaves, Congress can intervene to prevent that from happening. Okay, 14th Amendment is basically your second half of con law, right? There is so much in Section 1. I could spend months talking about these few sentences. So let's go clause by clause. Making good time also. By the way, this is my first day of class for con law. If you have it for con law, my first day is just this, but with much more detail. Section 1, all persons born or naturalized are citizens. And before about citizenship, you are a citizen by being born here, no matter what the state says. This was a huge revolution. Even if you've been born as a slave, you are now a citizen. And what do the citizens have? Privileges or immunities. These are the rights that no state can violate. So if you become a citizen, and with citizenship, you get these rights. Then the Constitution says, states cannot deprive any person of life, liberty, or property. That's due process of law. The Due Process Clause of the Fifth Amendment only protected the federal government's powers. This is now a limitation on state power. And the last one, no state can deny any person the equal protection of the laws. Today we think that means we treat everyone equally. That's not how the term was understood. Equal protection meant you protect everyone equally, right? You can't allow a KKK mob to lynch people because that's not giving them equal protection. It was understood very differently than it was today. Section 2 governs appropriation. If you deny people the right to vote, you lose representation, and representation is based on whole numbers. 100%. No more 3/5. This overruled 3/5 compromise. Okay. Yeah. You know, I've never had the occasion to focus on this passage, but this year, I might. People who engage in insurrection might not be able to run for certain offices. That was never relevant at any point in my law school career, but hey, what the hell? 2021. Okay. Section 5, very important. Congress can enforce this article. Congress was able to enact a number of civil rights acts in the 1860s and 70s to promote civil rights. The Supreme Court says several of them are unconstitutional. We say those in con law. 15th Amendment concerns the right to vote. The right to vote cannot be deprived on the basis of race, color, or servitude. In theory, this should have worked, but didn't really work because there were many ways that states tried to get around disenfranchising the freedmen. Okay? 13th, 14th, 15th were enacted in a very short span. 13th was banning slavery, 14th various types of rights and citizenship. 15th was voting. After that, the amendments get kind of more boring, right? You don't really care. The 16th Amendment is the federal income tax. Boo, right? Actually, I think all of you pay tax, or at least you should. If you don't, you will soon. Welcome to the real world, my friends. They're laughing in the back. The 17th Amendment is direct election of senators. Under the original constitutional design, the state legislatures pick the senators. 17th reversed it. 18th Amendment, boo. Prohibition bans the sale of intoxicating liquor. That one didn't last very long. We'll get there later. It was repealed. 19th Amendment, the right to vote for women, suffrage. So you had the right to vote for the freedmen, and like 50 years later, you get the right to vote for women. So just to get the progression there. 20th Amendment sets when the president begins his office. You know, January 20th, I think we had a presidential impeachment around that time. But the reason why we have this amendment is to shorten the lame duck period. Imagine if we had the president serving till March. So basically you have the election in November and he serves till March. It's a lot of time in the middle that stuff can happen, right? You know, making vocals as Chinese generals and stuff, right? A lot of things can happen in that period. Too soon? Sorry. I nuked that one. All right, 21st Amendment was the repeal of Prohibition. That one is quite popular. In fact, in Washington, D.C., there's a bar called the 21st Amendment, which is in honor of repealing Prohibition. Prohibition still exists. There are dry counties, we know that, but the federal prohibition is long gone. Query why we need a federal prohibition amendment, but not an amendment for narcotics and drugs. Think of that for a minute. Okay, 22nd Amendment. This is term limits. You can't be president more than twice. We know that President Roosevelt served or elected to 4 terms, and that was no longer permissible. 23rd Amendment basically said Washington, D.C. gets electoral votes. So one funny wrinkle of statehood, there's a movement to make D.C. a state, but it wouldn't actually make the entire D.C. a state. It would basically just say all the land around the federal capital is a state. But basically from the Supreme Court, the Capitol to the White House would be a federal enclave. Some people still live there. There are people who actually live within this boundary. And there's like 40 people live there. They would basically get their own electoral votes. Like 40 people would get to decide 3 electoral votes. Insane. I mean, just basically 40 people can flip an election. So they're saying you basically have to repeal the 23rd Amendment to make that work. Well, okay, good luck. The 24th Amendment bars poll taxes and other sort of devices to make it harder to vote. There was actually litigation this past year with mail-in ballots, is requiring someone to put a postage stamp on an envelope. A poll tax court said this ridiculous, go away, right? That the cost of a postage stamp was not a poll tax. I think that's probably right. Probably bordered on frivolous. 25th Amendment. Oh, God, I never had to talk about the 25th Amendment before. Oh, man. So if the president gets COVID, I'm sorry, if the president dies, the vice president, look, all these, I mean, say what you will, but Trump made the Constitution great again. All these obscure provisions became relevant that Molly mentioned that I had to talk about. Right, we had the president in the hospital. If he had died, the vice president would have ceded to the presidency. Okay? Then we have Section 3, which again became quite relevant. If the president can't discharge his powers, VP becomes acting. And then we have the Tom Clancy provision, Section 4 of the 25th Amendment, where the vice president and a majority of the cabinet agrees that the president can't discharge his duties, he's removed from office. It's very, very intricate, and you have to read it carefully. I won't try and do it quickly, but there were, of course, floating rumors the last couple of years whether to invoke the 25th Amendment, Section 4. We're almost done. We're actually right on target. The 26th Amendment may have been a mistake. I don't know. Lower the voting age to 18. I'll let you guys decide. I didn't know what the hell I was doing when I was 18. Maybe you did. The 27th Amendment is a good place to finish. It was actually first proposed in 1789. It was only ratified in 1991. And it says, members of Congress cannot raise their own salaries. Any increase in salary must take effect in the next Congress. We are done. Thank you so much. And thank you. And I welcome questions. I have to sort of plow through that very quickly but I'll be happy to take your questions.
I forget what the difference between privileges and immunities and privileges or immunities.
You nabbed me for Conlo, that's why. Privileges or immunities, privileges and immunities. So there's two clauses. In Article 4 of the Constitution, there's a privileges and immunities clause. That says a state cannot treat out-of-staters worse than their own people. The 14th Amendment has privileges or immunities. That says states cannot violate privileges or immunities. How do I remember it? Article 4 comes first, privileges end, because A is the first letter in the alphabet. Right? So if you remember Article 4, privileges and immunities, privileges or immunities, 14th Amendment. Christian?
You said that the amendments, the ones that's in the Constitution, was not actually the first one?
Yeah.
The third, what were the first two that you made?
Yeah. So the first two, one of them was actually this one, which said members of Congress cannot raise their own salaries. That was proposed all the way back in 1789. The other one governed, excuse me, the other one governed how representatives are distributed. It's kind of an obscure thing, doesn't matter. But this one survived. It's actually a funny story. There was actually a student in the 1980s who said, wait a minute, this amendment was ratified by a certain number of states. We can push it forward. It was actually ratified much later. I'm not sure if it was valid. I think it might have gone stale, but what do I know? All right, what other questions you guys have? Ask me anything, as they say. Nothing? No questions?
So the mandate.
Raise your hand. I can't see mouths moving. It's a weird thing about COVID. Yeah, okay, go ahead, right there.
So.
I hear a sound emanating.
Biden's vaccine mandate. What's the future of that look like?
No, I just say ask me anything. Well, the vaccine mandate isn't only a matter of constitutional law. It's also a matter of administrative law. The vaccine mandate was not actually imposed on all people. It was imposed on workplaces, specifically employers with apparently 100 or more workers. And the president relied on a legislation called OSHA, the Occupational Safety Health Act, which usually governs workplace safety. You have to have PPE, you have to have equipment to be safe. I think there's a good argument that the sort of OSHA Act doesn't support the sort of broad mandate. It's never been used to require vaccines at all, let alone vaccines for 100 million odd Americans. So I think there's serious legal vulnerability. But frankly, I don't think Biden cares if he loses. The fact that he imposed the mandate's enough because companies will simply comply. And if a few lawsuits are successful here and there, it won't really matter. So ultimately, it's not going to matter.
So
Please, yes. See, I can't see mouths moving, so I have to sort of just guess where the sound's coming from. It's like one of those hearing tests, where the sound coming from.
So when the executive is governing by, yes, not really executive action, just social peer pressuring. Like you just said, whenever companies are just going to go ahead and enact it because he said it doesn't matter if he has the actual legal authority to do it. But what are the ramifications of that? Or how do you address them?
Yeah, so let me answer the question a little more broadly. Very often with an executive branch, they have an old statute. And that old statute can be read in a very broad fashion. And they realize there's some new conflict, and I can use an old statute to address this new conflict. My own perspective, this is Josh talking, is I'm skeptical. When you take a 50-year-old statute that was enacted by President Nixon and say, aha, President Nixon gave us this power to impose a vaccine mandate for COVID. I'm like, okay, that's not what the statute says. But other people take a very broad reading of federal power and say, well, the statute's kind of vague. It says workplace safety, COVID makes one safe, good enough for me. And so I think there's a very strong jurisprudential divide of how you approach this issue. I would say Congress pass a new statute, then we'll talk. But I'm not in charge, thankfully. Lord help you if I'm not in charge. Lord help you all. What other questions you have? Yes?
Do you see potential for any future amendments that might be added to the Constitution? Or any that have?
Yeah, and someone's going to ask that. So there's one that might have already been ratified, but we're not sure. Something called the Equal Rights Amendment. Have you heard of this? It became very popular in the 1970s and 80s. I don't have the text in front of me, but it basically says you cannot deny rights on the basis of equality of sex. I'm just paraphrasing. This was very big before the Supreme Court started to recognize that gender discrimination laws were unconstitutional. So in many regards, the law has become obviated. It hasn't become as necessary, but it was very popular in the 70s. The amendment itself said it had to be ratified by a certain year for it to be effective. That year was in the early 80s. I don't have the year in front of me. It didn't happen. Congress then tried to extend the deadline, unclear if the extension is even valid, and they still didn't make the deadline. But the last couple of years, when a number of red states turned blue, they decided to go ahead and ratify. Virginia, I think, was the final one. So there's an argument that was advanced that it's already ratified. The courts have not yet accepted it. And it's unclear who even gets to decide. I mean, it's kind of absurd, but the Archivist of the United States has to basically accept the amendment. It's kind of like a formal process, but it's not there. There will be bitter litigation over that amendment because if it's ratified, just keep in mind, the phrase equality of sex meant to be one thing in the 70s, means a very different thing today. And if we take the contemporary definition in 2021 of what equality of sex means, that could have significant implications for a lot of gender rights issues. So, will that be ratified? I'm doubtful. I think that even Justice Ginsburg said that the time passed to ratify the ERA. The time has already passed. So I think she's probably right about that. What else you got? We have someone new? Yeah, Vikesh. I'll come back to him. I know where he is.
So something recent that I was reading about was financial privacy and how the government wants to see transactions with dollars.
Are you talking about cryptocurrency? What are you reading about?
No, it's just like any sort of transaction or any account that you have, anything that has like a value over $600, the government wants to be able to see it. That's something that kind of came out in May, so recently, under the Biden administration, the Treasury Department's looking to move forward with it. What gives them that power? What part of the Constitution, that broad aspect, where are they pulling that from?
Yeah.
Nixon wiretapping.
Well, I'm not sure if I know the exact answer to your question. Generally, most federal powers comes from a combination of the Commerce Clause and Necessary and Proper Clause. Any economic activity that could have a substantial effect in, just say, commerce within the federal authority under precedent law. I don't think that's correct, but that's our doctrine. That's our world we live in. So whatever financial regulation is some sort of economic activity that substantially affects, just say, commerce. Necessary doesn't mean what you think it means. Let's go back to John Marshall being overrated, right? John Marshall said that necessary means like convenient or useful. Those are the adjectives he used. So necessary doesn't mean strictly necessary. That's what Jefferson is. Jefferson said necessary means absolutely necessary. And Marshall's like, no, it's good enough. Flexible. Good question. All right, other questions? I'll go back to Reed. All right, Reed, what do you got?
What is between the next, the coming October, November terms, what do you think is going to be the biggest development in Hong Kong? Which game?
Abortion's gonna be a biggie, right? I mean, it's sort of either do or die. The court will either overrule Roe or it won't, and then we'll know for sure what the next law is next 20 years. It's going one way or the other. I don't know. What other questions you guys have? This is nice talking to real human beings. I missed it. I forgot what it was like. Anything else? No? All right. Thank you all so much. I'm happy to stick around and take some questions. Thank you.